Well, my thing is, technically, is that a violation of the law? Yes. But is it a violation of the spirit of the law? It appears that it is not.
This case is one of those rare moments where the law, the facts, and common sense don't quite match up. Meet Frank Garza, a man with a felony record, a history of mental health struggles, and a claim that could completely change how you see him. On this day, he says he wasn't out committing a crime. In fact, he insists he was trying to prevent one, picking up a gun he says someone else had abandoned under a bridge, and calling 911 to turn it in. But here's the catch: possession is possession, at least in the eyes of the law. The state is pushing for a conviction. The defense says it's a misunderstanding, and the judge? Well, let's just say she's not sure justice is being served here. Stay with me, because as this case unfolds, you'll see how one missing piece of evidence, a single 911 recording, could be the difference between a prison sentence and freedom.
Court is calling 2025 CR 005952, State versus Frank Garza. Can I have parties announced?
Duffy Pitlock for the state of Texas, Your Honor.
Donald Wilson for Mr. Garza.
And are you Mr. Garza?
I am.
Counsel, have you received all discovery and did you review that with your client?
Yes, I have, Your Honor.
Court will find that the state is in compliance with discovery. Counsel, I see in the notes that there was a competency evaluation done.
Yes, Your Honor. It was, and it came back that he is competent, and I agree with that.
All right, and he's already been deemed competent by that court and that judge?
That's correct.
All right, thank you. Mr. Garza, did you review the true bill of indictment with your attorney? Did you understand it?
Yes.
Counsel, do you waive the reading of the indictment?
Yes, I do.
State, are you proceeding on the indictment as presented?
Here's where it gets interesting. The state isn't even going after the original charge. They're already stepping it down to a lesser offense, attempted unlawful possession. Likely because they see weaknesses in the evidence. In Texas, a third-degree felony carries anywhere from 2 to 10 years behind bars. But even with the reduced charge, Frank's prior felony conviction means there's no wiggle room if the court finds he had a weapon in his possession, intent or no intent. This is the razor's edge where technical guilt meets possible moral innocence.
No, Your Honor, we are not. We are proceeding for the lesser included attempted possession to make this a third-degree felony.
No objection, Your Honor.
All right, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Did you understand that the state is proceeding on the lesser included offense of attempted unlawfully carrying a weapon with a felony conviction as a third-degree felony? The range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand? You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. Did you understand by entering this plea, you were giving up those rights?
Yes.
And did you intend to give up those rights and enter into a plea in this case?
Yes.
Counsel, has your client been able to provide you with any defenses?
Yes, he has.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, I believe so.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, I do.
Mr. Garza, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No.
Anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
I am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes.
According to the plea, the state is proceeding on the lesser included offense of attempted unlawful carrying of a weapon with a felony conviction. They're asking that your punishment be assessed at 2 years in the prison and you to forfeit the firearm. Did you understand that to be the plea?
Ma'am.
Defense?
Yes, it is.
Let's pause here for a second. Think about this. You're in Frank's shoes. You say you found a gun, picked it up to keep it out of the wrong hands, and called the police to turn it in. But because of your record, just touching it is a felony. Should the law treat you the same as someone who was armed with bad intentions? Or should there be exceptions for situations like this? Drop your thoughts in the comments, because this is the exact kind of gray area that divides juries and judges.
State,
Yes, Your Honor.
did you review the waiver of appeal paragraph with your attorney? Did you understand it?
Yes.
And did you sign it in both places? I'm sorry?
I did.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, are there any such motions?
No, Your Honor.
Then to the lesser included offense, how do you plead? Guilty, not guilty, or no contest? State any evidence?
State offers State's Exhibit 1 and all attachments, Your Honor.
Okay.
All right, state, you may be excused.
Thank you, Judge.
Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand? Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments and review the same. All right, after reviewing State's Exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Yes, Judge, this case is kind of,
Now we get the defense's side. Frank's attorney paints a picture of a man who's fallen on hard times, homeless, battling mental health issues, but competent to stand trial. The gun? He says Frank didn't buy it, steal it, or even carry it for protection. Instead, it was found downtown under a bridge during a church gathering, and Frank supposedly grabbed it to call 911. If that's true, this isn't your typical illegal possession case. It's more like a public safety intervention that got tangled in red tape.
unfortunate one. Mr. Garza is a resident of Haven for Hope. He suffers from some mental health issues that have been checked out, and he is, I believe, competent and has been confirmed, but he does have problems related to prior injuries that he's had. And this particular day, this weapon was found downtown under the bridge by some other boy. And Mr. Garza picked it up to try to turn it in. He was literally on the phone with 911 on UTSA property whenever he was spotted with a gun on property, and that's what led to this. We've looked at pursuing this to a trial and all that, but Mr. Garza has been locked up for more than 6 months. And he has elected to take this plea. He was in possession. He is a convicted felon, so it meets the technical, allegations, but that was the reason that Mr. Garza has chosen to move forward with this case.
So a gun was discovered and he was calling the police to turn it in.
He took it, it was during the church under the bridge. He
Mhm.
went to use a phone from one of them, which is on the UTSA property, and was, as I understand it, on the phone when UTSA security saw him and came over. And here we are.
Well, my thing is, technically, is that a violation of the law? Yes. But is it a violation of the spirit of the law? It appears that it is not. So I don't know if there's proof of what he's saying or not. Based upon what I'm reading, it's not what's being said. I don't see it in the police report. So,
And with the nature of the offense and the people around, the witnesses, it's a challenge. That's what the defense is faced with, and that's the reason Mr. Garza has elected to.
and I'm assuming that's the reason why the state is proceeding on the lesser included.
As well as the minimum.
All right. Then the court will find you guilty of the lesser included offense. The court All right, so here's my thing. We can go off the record. I understand why the state would proceed on the lesser included offense, and I may be overstepping my bounds here. But if what is being said is true,
This is one of those rare moments you can feel the judge wrestling with the very meaning of justice. She admits, yes, it's technically possession. But is that really what this law is meant to punish? Her words cut to the heart of the matter. If someone's trying to get a dangerous weapon off the streets, should we lock them up for it? It's a bold stance, and not something you always hear from the bench. But here's the tension. Without proof, like that missing 911 call, the state still holds the cards.
doesn't seem just to the court. I mean, if somebody finds a gun and they're picking it up and on the phone to call the police to say, hey, I found a gun, come and pick it up. Legally, is it possession? But this is not what this law is meant for. Am I wrong? And I understand state why you're reducing it, but do we have any proof of this? I'm telling you all, if there's proof of what he's saying, that he was on the phone, and it appears that there was the gun didn't have any, wasn't loaded or anything.
Your Honor, you do speak to a good point. If there is proof, there has been requests for things that have been alluded in the police report, things that would have corroborated.
Mhm.
The state has not been able to receive those things. There have been discussion with defense.
Mhm.
The state understands if it came to a, he said, we understand and believe the report. Things have been requested that we don't have. And
And who would have these things?
we've requested specifically without, jumping around the 911. We do not have that. We cannot corroborate.
And there it is, the crux of this entire case. The alleged 911 call is nowhere to be found. If that recording exists and backs up Frank's story, it could flip this case on its head. But without it, the court is left with nothing but his word against the police report. Think about how much power a single piece of evidence can have. One phone call could mean the difference between serving time in prison or walking free.
So where's the 911? Does the 911 not exist?
It's been requested and I haven't gotten word back. Now, we believe with the report, we have the elements.
Yes.
Yes.
No, I mean, you do have the elements, and you actually have the elements for unlawfully carrying a weapon with a felony conviction, because he has a felony conviction. He was carrying a weapon. So I can sentence him now, or if you want to wait, I can not sentence him today, and they can see about the 911 call.
And Judge, I'll talk to Mr. Garza. This case was set for a couple of weeks from now. Mr.
Mhm.
Garza has asked me to push it up to move the case.
So, Mr. Garza, do you understand what's going on?
The judge takes a moment here to explain the law in plain English, and she's not sugarcoating it. Once you have a felony conviction, it's illegal to possess a firearm. Period. No exceptions for good deeds. But she's also pointing out the unintended consequences. The law is meant to keep dangerous people from being armed, not to punish someone for trying to secure a weapon until police arrive. It's a reminder that in the justice system, context matters, but it doesn't always carry legal weight.
Just a little bit.
All right, so here's the thing. You're not allowed to possess any weapons if you have a felony conviction. And then there's some things, if you have a family violence, you're not, an affirmative finding of family violence, you're not allowed to possess any weapons either. And that's what this law is for, right? And so from reading the police report, you're guilty, right? Because you had a weapon. But if you found a weapon, you picked it up, and you were calling the police to say, hey, I found this weapon, could somebody come and pick it up? To the court, that's not what this law was meant for, because it's more danger to have a weapon just laying around where a child could pick it up or somebody else could pick it up than you're picking it up and calling the police and saying, hey, I found this weapon. And what I'm reading in the police report is that officer comes up to him and he's like, yes, I do have this weapon, and yes, you may search my backpack and everything. So you can discuss it with your attorney if you want. We can recall it back in 2 weeks. Here's the thing. If it turns out that they can't get the 911 call and you still want to go forward with the 2 years, you'll have the 2 years. And you'll get credit. So if we come back in 2 weeks and you end up getting 2 years, guess what? You're still going to get credit for the time that you were waiting for those 2 weeks. It's just you'll be at the Bexar County Jail and not at the prison. It's completely up to you. But for the court, I don't think, and I could be wrong. If I'm wrong, somebody correct me. I don't think that's the spirit of that law. So,
Judge, I'm in agreement with you. It's up to Mr. Garza.
Okay, so can you explain that a little better to me?
all right. So the state has offered you 2 years.
Okay.
I will follow that 2 years if the state, if they go and they're not able to get the 911 call because they say they've been trying to get the 911 call. If they are unable to get the 911 call, you'll still have the 2 years. So your waiting 2 weeks is not going to change your position as far as the agreement that's been worked out by your attorney.
And that's where this hearing leaves us. A man with a felony record, a weapon he says he was trying to turn in, and a missing 911 call that could make or break his defense. The judge clearly sees the moral gray area, but the law is the law. Without that proof, Frank is still facing 2 years in prison. This case is a powerful example of how justice isn't always black and white, and how sometimes the smallest detail can carry the heaviest weight. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.